versus Lloyd Sanders. Can I get your appearance?
Yes, good afternoon, Your Honor. Jake Kuzicki on behalf of Mr. Sanders.
Mr. Sanders, can you tell me your name?
Yes, ma'am. Lloyd Sanders.
Okay, Ms. Havner is on her way up, so here she is. Hello, Ms. Havner. Can I get your appearance?
Chelsea Havner on behalf of compilations.
So this is, I just want to make clear for the record, Mr. Sanders was just here, was this last week?
It was on 1/9.
1/9 for a first technical violation on his probation. And he was here and he had this technical violation for failing to enroll in testing by 12/7 as directed, failing to appear for oversight appointment as directed, failed to appear for ISP status hearing. It wasn't you, it was Mr. Fanto, but at that time, Mr. Sanders had just gotten out of treatment, and the idea was we'll just pause that until when?
2/6 next week.
February 6th, to give him a chance to get acclimated and get everything going, and then we'll see how he's doing. So that was his first technical, which we haven't had a hearing on. So that will now be the second technical. And this will convert to a first unless are we doing them both today?
Yes, Judge, we can handle them both today.
Okay, but they're written separately. So you have a first technical, and the first technical is for failing to enroll in testing by 12/7, failing to appear for oversight appointment, and failing to appear in your ISP status hearing and as scheduled. Do you understand those allegations against you?
Yes, ma'am.
Okay. Violation advice or rights form with your attorney?
Yes, ma'am.
All right. And did you understand your rights?
Yes, ma'am.
And did you sign and date this form, sir?
Yes, Your Honor.
Okay. At the maximum possible sentence I can give you on that first violation under Michigan law is 5 days. You understand that?
Yes,
5 days counting. So you understand you have a right to a hearing, and at that hearing, it would have to be proven by a preponderance of the evidence. That's like 50% that the violation occurred. Do you understand that?
Yes, Your Honor.
And you understand if you enter a plea of guilty, that you'll be waiving those rights to a contested hearing.
Yes, Your Honor.
We're not going to have a hearing if you enter a plea. That makes sense, right?
Right.
Okay. To the allegation that you failed to enroll in testing by December 7th, how do you plead?
Not guilty. Or guilty.
Guilty?
Guilty,
Did you
yes.
enroll in testing by 12/7?
No.
Okay. That you failed to appear for your oversight appointment with Ms. Havner as scheduled, how do you plead? For ISP status hearing as scheduled. All right, I'll accept those pleas as knowing and voluntarily given. And I'm going to, Ms. Havner is not recommending jail on that first violation. We'll get to, or is your recommendation remain the same on that, Ms. Havner?
It does. I did tweak it today since I was able to get him on the phone with Dwayne. He has an appointment with Hygera on 2/4 at 9 a.m. next week. So I just amended that, and then he has to enroll in testing upon release if he does get jail for the second technical.
All right, so I'm going to adopt the recommendation. He's already enrolled in testing now. I know the allegation is he's not going, but he's enrolled.
Yeah, yep.
Okay, so
Yeah,
I'm not,
re-engaged, sorry.
so that's, doesn't need to be, to attend your substance abuse evaluation on February 4th, which is next week. You're to complete you have 2 additional days of community service in the city of Taylor within 28 days. So that's the sentence on the first technical violation.
And Judge, if I could, the reason why I still left as enrolled is because he would like to go to a new agency, ABCS. They just opened up a facility in Westland, and we completed the referral today. So
For what? For drug testing?
yes, yep, it's a facility. It was the one that's out of the 16th District Court, and they had other locations in Highland, Michigan, Detroit. They just recently opened up new locations. I believe like Pontiac, East Point, and one west is Westland. He does live in Canton, which would be more feasible. Right?
That's what is, as long as he's testing an income fact. All right. Now we have the second violation. I can give you 10 days on this. That's the max.
Yes, ma'am.
And the allegations here are that you failed to test as scheduled on, you are not off to a good start, sir. January 11th, 16th, 18th, 20th, 21st, 23rd, 24th, 26th, and 27th. You understand that allegation?
Yes, Your Honor.
That you failed to appear at your status hearing on January 21st. That's a violation. And that you failed to attend 2 pro-social meetings weekly since January 13th. And that you tested positive for cocaine on January 30th at the probation appointment and admitted to use. Do you understand all those allegations?
Yes, Your Honor.
And again, you understand the advice of rights form that you went over and signed and dated. If you enter a plea, you'll be waiving the hearing rights, right?
Yes,
And waiving the presumption of innocence, because you're pleading guilty, if you plead guilty. Do you understand all of that?
Yes, Your Honor.
All right. That you failed to test on January 11th, 16th, 18th, 20th, 21st, 23rd, 24th, and 26th, and 27th. How do you plead?
Guilty.
To the allegation that you failed to appear for your status hearing on January 21st, how do you plead?
Guilty.
That you failed to attend 2 pro-social meetings a week since January 13th, how do you plead?
Guilty.
And that you tested positive for cocaine on January 30th at 25 at your probation appointment and admitted use, how do you plead?
Guilty.
Mr. Gazicki?
Your Honor, I know there's a recommendation incarceration. There's a lot of violations. I'm aware of that. Also aware that he's scheduled for inpatient next week. Mr. Sander acknowledges he's got a major problem. He's having a hard time to cope. And I don't think really the jail, I'm no expert. I don't think jail, the place for him to hold that jail in advance. He has support. He has his mother here. His violation was because he was with the wrong girlfriend, correct?
Yes, sir.
And he's not seeing her now. So I'm asking the court not to do the 3 days in jail. He works, he has to pay his child support, and obviously be, children involved in this situation if he doesn't pay his child support.
Okay.
So I'm asking the court to delay the sentencing on jail.
All right, thank you, Mr. Gazicki. Look, I'll be honest with you, Mr. Sanders. I'm limited in how much jail time I can give you. The max I can give you right now is 10 days. And I know you have an appointment to start your treatment next week. And that's the only reason you're not getting 10 is because part of being in the intent get you treatment, right?
Yes, ma'am.
But you've done inpatient, you know what you're supposed to be doing, and you're not doing it. And like trying to blame it on a girl is like, I just heard strawberries infused with alcohol. Like I hear everything.
Yes,
So I know this is all a girl's fault. This is all your fault. And you listen, you had a felony reduction. Again, I don't have anything to do with plea agreements. You had a felony reduced down to a misdemeanor, right? You get this benefit. And all you have to do is comply with probation. And right now you couldn't possibly be doing any worse than you are, right? And before my hands were tied by the legislature, if you were in front of me before this change in the law, I would literally just give you 90 days right now, or however many I could give you, 6 months. And then I would just close you. But I have to let you violate 2 more times before I can do that. Right? 2 more, and I can do it. And if you continue going the way you're going right now, like this is going to be very easy for me. I won't lose a wink of sleep. I'll just put you in for your however long I can and keep society safe for as long as I can. And then you'll be done with this court. That's my plan. If you can't comply at all, that's all we're doing. We're just waiting for you to do this 2 more times so I can throw you in Wayne County. Okay?
Yes.
I don't know what you're thinking. Like you just don't show up. Like any other person before the legislature in their infinite wisdom changed the law and tied judges' hands with what we're allowed to do when we have in front of us. You'd have gotten it, and almost any judge would have given it to you for this violation alone. So Ms. Havner's recommendation is that you do 3 days jail. You're going right now. And that you get a peer recovery coach through GrowthWorks, and you're going to start attending that as well. And you're also going to continue with all the other conditions. And when I say continue with the conditions, I mean actually do the things, right? And just know when you get out, I think you should be in jail right now. So you can prove me wrong, or you can prove me right. These are your choices. But this, what you're doing right here, this is not acceptable. We're gonna give you a chance to show up to your treatment. You could just go do your time in county, and none of us have to go through this anymore, because you are off to a terrible start, sir.
Yes, ma'am.
All right,
Judge, if I could just have him, initial and sign the peer recovery form so I can get it sent over before he.
Sure. We have an excellent peer recovery coach that you could work with. If you want help, if you want to be better,
Yes, I do.
and Mom, don't fall for his nonsense. Don't fall for what he's selling,
What's that?
because he's full of it.
Okay.
I'm sorry.
And the only way treatment's going to work for him is if he's not being enabled by people who love him.
All the next doors is going downtown.
He's going downtown.
Right.
Unless they decide to hold him next door, the paperwork will be for county.
Okay, thank you, Judge.
Council, state your appearances.
Good afternoon, Your Honor. Amy Riser on behalf of the people.
James Thomas on behalf of Mr. Radcliffe, Your Honor.
All right. Mr. Thomas, this is the defendant's motion, so you may proceed.
Thank you, Your Honor. Would you prefer me at the podium, or since I'm spread out here, can I do it?
Either way.
Judge, I'm going to start off with just talking about where we're at as far as this motion is. As you're probably aware, my client's been incarcerated for about 105 days at this point. He currently has a $3 million bond, which under the circumstances I feel is unreasonable. And I think that once we say part of our burden under the law is to show that there isn't a great amount of evidence, or that the presumption is great, that the evidence of guilt is there. And to go through that, Your Honor, what I'm going to do is I'm going to kind of surmise the evidence a little bit here from what we've looked at. And I would tell the court, as of just yesterday, I just received another supplement in regard to this case.
All right.
Of course, the last time we were here on the 9th of January, I believe, I think that was the last PCC. The last time we were here, I had asked whether there was any other outstanding warrants that were involved or anything. And then I became aware that now I guess there's some Snapchat warrants. But at any rate, Your Honor, just to go through a cursory account of not great evidence or a presumption of guilt in this case in regard to the evidence, simply would turn and talk about the FBI report that was given to us, where one of the victims in this case went to the FBI to lodge a complaint, which was really the beginning of this case. And upon a cursory review of that particular investigation that was conducted by the FBI, they found that they didn't have any Facebook or YouTube channel or Instagram. Everything was negative or for derogatory information in regard to that. Notwithstanding that, and again, this is me reading this report, that this allegations that were made were like multiple sessions that allegedly occurred. But when the investigation went back to the state police, it's one time. So there's a difference in that, and years or whatever it was. So that was the beginning, which led into other things. Going into an investigation for Yahoo, and going into his email address, going into all these videos and whatnot that were alleged to have been passed back and forth between the different alleged victims and whatnot. There is no CSAM. So there's no CSAM in this case that is in my possession that I've seen at all. And obviously that's a problem, because back in November, as you're aware, there was a 12 count complaint that then turned into a 31 count complaint. And the magnitude of charges doesn't make this case any more significant. You can't continue just to stack charges. CSAM, they need CSAM to prove their case, and they don't have it. They don't have any of this stuff. So the presumption, the evidence of guilt is not there. And again, I'm going to get into the other part of the hurdles of this case. but it's not there. We don't have any of this stuff. You know, going to, again, looking at the Google ones that were sent out, nothing. There's no evidence in regard to any of these transactions that were allegedly occurring between the people that are involved in this case and the defendant in this case. Now, the court is obviously well aware that when you're charged with capital offense, you know, obviously part of this for us to show that there's a lack of this evidence. Well, we got the response from the prosecutor's office yesterday in regard to our allegations in our motion, and I'm sure the court, I don't know if you've had an opportunity to review it or not at this point. Here's the part that I have a big problem with, Judge. You know, when 6, 7, and 8 are the meat and potatoes of our motion, which the prosecutor's office answers they can either admit or deny. And obviously, you can't admit or deny and then put that we need to show our proofs on this, totally shifts the burden to us. We don't have a burden. The standard of proof for us is nil. We have to prove nothing in this case, Your Honor. And I find it kind of, you know, as a 28-year-old lawyer, I find that kind of, you know, kind of disingenuous. The answer being either we don't admit or deny when you have a 31 count complaint that my client's facing with a $3 million bond that can't get out of jail is not reasonable. I just don't think that that's right. If you're going to deny something, that's fine. I don't have the basics of why my client is incarcerated. I have an issue with. And so I want to, you know, I hope that the court will take that into consideration, you know, when considering whether or not we've met the standard that this case does not have the evidence that it needs to continue to hold my client on a $3 million bond. The court was given, you know, today, I don't know if you had an opportunity because there was 11 letters that I submitted as a supplement this morning, Your Honor.
Counsel,
I
you haven't been before me, but I read everything. So yes, I've read.
Okay. And I appreciate that, Your Honor. I also, and I don't know if I showed this to the prosecutor. These are like 6 or 7 more letters. I don't expect you to read them right now, Your Honor, but can I approach you
Any objection to the court receiving the additional letter?
I'll do another supplement and admit them
All right.
to the clerk's office, Your Honor. So let's talk a little bit about the flight risk. And I think that, you know, with the danger of the community and whatnot, the things that the court would be concerned about, obviously, to make sure that my client shows up for court. So we have all those letters of support, you know, as far as my client goes. You know, he is a lifelong resident here in Michigan. He's never lived anywhere else. He doesn't have a passport. He doesn't have, he's indigent.
Didn't he live in Virginia or no?
No, he never.
No. Okay. Go on.
He went to school there, but you know, when you're a student, you don't have to.
Yeah, but I mean, he was there at Liberty, right?
As
Or
a student,
no?
I believe, Your Honor.
Okay, okay. I just want to make sure that while he may have been a Michigan resident, is that right?
It's fair enough. Yeah.
Okay. All
That's
right.
fair. I've always known it, whether you're in the military or if you're a student out of state, you're not really a resident of that state unless you claim to be a resident of that state, because you don't have to get a driver's license from that state if you're either in the military or you're a student. I don't know if the court knows that or not, but I know
I attended school out of state. He may have been back with the dinosaurs, but same rules apply. Go ahead.
All right. Well, his ties to the community, obviously his family, friends. I mean, he has all these people that are sitting in these rows here in his support here today, Your Honor. I'm sure some of them that are here wrote some of those letters. He's not going to be a flight risk. He's not going to be going anywhere. And, obviously I'm his attorney, and I'm going to be on this case to its conclusion. He doesn't have alcohol abuse or drug abuse or anything like that. He's never even used any of that stuff. There's allegations from some of the people in this case that he has, but there's absolutely zero evidence of that. And obviously, my client would obviously tell you that he does not have any issues whatsoever with any of that stuff. and he doesn't have a criminal record and no juvenile record, in furtherance of that. So these are things that I think would be important, to the court. Obviously we feel that he could get a job, doing something if he were to get out. He doesn't even need to stay in this county. He has a sister who lives in Lenawee that he could stay with if need be. And obviously the other thing would be, if he needed to wear a tether or something like that, he would do anything the court would require him to do. I'm also going to talk a little bit about, and again, just because you file a magnitude of charges on somebody doesn't mean that you can file 100 charges on somebody. If you don't have the evidence to prove those, you can't just say, well, the magnitude of charges merits a high bond. That's ridiculous. It shouldn't work that way. Bail doesn't work that way. I would also cite the court to a case, which is the People versus Davis. It's a Michigan Court of Appeal case from 2021. Basically, that under Michigan law and under the Constitution of our state, that you have a right to reasonable bond and reasonable bail, and based on your circumstances. And my client's indigent at this point, so a $3 million bond is tantamount to zero bond. I mean, even if it was $1 million, it's still tantamount to no bond. Lastly, Your Honor, I'm going to talk a little. We had an evaluator go in there, psychology, Dr. Schaefer, Kathleen Schaefer, who I believe, and I'm not from washtenaw, but my understanding from my communication, unless I'm wrong, that she's been a doctor for the prosecutor's office also, and so in Washtenaw, I don't know if that's true or not, but I believe that that was something that she proffered to me. But she's also went in and saw my client. I attached the 4-page report. I'm not going to go into the report, read it to you or anything. But obviously, he's a very low risk for repeat violence. She scored him as low on everything, pretty much, Judge. And obviously, we had that done for the reason of this hearing. And I think that taking that into consideration, the court can certainly take other if he were released on some type of bail, that no contact orders and all these other things that the court has an absolute right to implement and put on my client, to make sure that he's going to not only comply with the court's orders and showing up in court and doing what he's supposed to be doing while this case is ongoing, but also obviously it would be a great help to go through this evidence and prepare for this case in the upcoming court date, and that's going to be very important to our defense and being able to be properly prepared to defend this case. And again, Your Honor, just looking at the evidence, I submit to this court that you can point a finger and collaborate and do whatever you want, but just pointing a finger, it's just an accusation at this point. And accusations where the investigation that was conducted in this case, with all these things that were supposed to be passed, has been passed, either from him, which would also, which I didn't bring up, but which also would include a VHS, a camcorder, 7 VHS that were found in his house. And he had no time to try to hide anything or clean anything up or do any of that stuff. His house was search warranted, and they went in there and confiscated all this stuff and still didn't find anything. So on top of that, Your Honor, I would just say that, obviously, if the people that are making the allegations said that they sent things through ISPs or IP addresses and through their email or through that, and yet the prosecutor's office has had the opportunity to do all these things, subpoena all these records, try to get all this stuff and not be able to produce one piece of solid evidence, and then say, well, we don't admit or deny to any of these allegations. So, Your Honor, I'm asking the court today that what I would think would be a reasonable bond for my client would be $10,000 in that range, and possibly if I think a tether or anything else would be amicable to any of that, Your Honor.
All right.
Thank you.
And
Yes, sir.
had a couple quick, and so that you understand both parties, sort of what the court's analysis and looking at the issue of danger to the community and the flight risk. When I go through the prosecutor's response, some things kind of jump out at me. Okay. One of those being, I mean, there wasn't the particular victim, but when the behavior as I see it laid out is certainly, I mean, and I know they're going to have to prove their case, but is very predatory in terms of sort of the connection of the alleged victims in the case. Okay, so that's one issue that is the court. One of the other things that the court takes into account, because, you know, unless there's been some prior behavior on the defendant in terms of that they're going to, that they have fled or not appeared for a court proceeding, or those behavior directly related to the court. One of the things that the court looks at is, does the individual do things that in the court's mind may either lead or obstruct an investigation or do something that might be obstruction of justice? So that's something that, and I would tell you that the court looks at that. Where I weigh it depends on the particular case or the nature of the case.
Do you have an example, Your Honor, of what you're talking about?
Well, if you look through the prosecutor's response, there were, and I guess I wanted to get the defendant's response to it, which may just be it didn't happen, but there are indications that during and at what point there were calls or communications from your client to individuals that are now alleged victims in this case, to, if they're contacted, to not say anything, or if contacted, to support the defendant.
Right.
And there were at least 2 or 3.
And what I would say, Your Honor, is there's
Go
cell
ahead.
phone records that should exist. If my client called them or vice versa, then the cell phone records that in 2024, pretty good. You know, if the prosecutor's office thinks that my client was calling them and telling them that, then produce those records to say,
Well,
here's X
but
number.
counsel, you know, I get it, but I'm not at the point of prelim or that. I'm looking, you're asking me to reduce bond. There are certain things that I'm looking at that I'm telling you that cause the court alarm. And one of those things